everyone, and thank you for joining us for our today's webinar, Copyright Essentials, Myths Explained. My name is Alicia Morris. I work in the Public Information Education Office, and I'm the host of today's webinar. Before we start, I'd like to share just a few logistical announcements with you. During today's webinar, you will be able to submit questions using the Q&A button at the bottom of your screen. We will answer these questions after the presentation is complete. However, we may not be able to answer all of the submitted questions. Furthermore, please note that since this session is being recorded, if you choose to participate and your question is addressed, it will be included in the recording as part of this webinar. And now I would like to welcome our today's moderator, George Durrani, the Deputy Director in the Public Information and Education Office. Hi, George.
Fact or fiction? Let's find out. Copyright has been around a long time. In fact, the mandate for copyright protection is embedded in the U.S. Constitution at the founding of our country. It was important then, and it's even more important now. Today, there are so many creators, songwriters, authors, photographers, musicians, playwrights, bloggers, poets, social media content creators, creative people of all types expressing themselves. The copyright law is full of many provisions to help create a balance of protections for copyright owners and for those who responsibly use those copyrighted protected works. Copyright is present in everybody's life in ways that you might not even imagine. So there are a lot of facts about how copyright works. There are also a lot of myths. How can we tell the difference? Well, this is your lucky day because we have with us two experts who can help sort out the facts from the myths. Today's webinar features Jessica Chinnadurai and Laura Kaiser, who are both attorney advisors who will guide us through this journey. So take it away, Laura.
Thank you, George. Good afternoon and good morning to those on the West Coast. Thank you, everyone, for joining. We are thrilled that so many people want to learn about copyright. This is an updated version of our March webinar, backed by popular demand, and we've added a couple of new resources and myths for you all today. So before we get into our session, just a few additional logistics. The event is being recorded, as Alicia mentioned, and captions are enabled. And the links to the resources we'll be highlighting today are going to be dropped into the chat throughout the program, but we've also made them all available on the event page for this webinar. So you can visit the link that's in the chat now, and you can access all of the resources in one place. There's also going to be a survey after this webinar, and we would very much appreciate you completing that because we develop programs like this with your feedback in mind. We also have a public information office who you can contact if you have any questions that aren't answered by today's presentation. We'll put the contact form for that office in the chat. So today we're going to start with a very brief overview of the Copyright Office, and then we'll talk about some basics of copyright law before getting into our myths. And we will, of course, explain what the truth is. And as I mentioned, we'll give you all some links to our resources, so keep an eye out for those. Now, as George mentioned, your presenters today are myself, Laura Kaiser, and my colleague, Jessica Chinnadurai. We're both attorney advisors in the Public Information and Education Division in the Copyright Office. We frequently participate in outreach projects to educate the public about copyright issues, such as this webinar, and we're both very excited that you've joined us today. So let's get started with the Copyright Office. The U.S. Copyright Office was founded in 1870, and we are a federal government agency that's part of the Library of Congress in Washington, D.C. So we are part of the legislative branch of government. And when we talk about the Copyright Office administering the Copyright Act, that's a pretty broad statement. It includes a number of different roles and responsibilities. So let's look at the various ways the U.S. Copyright Office carries out its mission. We have several important duties that help fulfill copyright's constitutional purpose. Our mission statement is to promote creativity, and free expression by administering the nation's copyright laws and by providing impartial expert advice on copyright policy for the benefit of all. Our small but mighty staff of about 450 employees is responsible for many different things. First, we make and maintain records that provide details on copyright ownership, which includes registration as well as recorded documents about transfers of ownership. We also administer statutory licenses and help manage and distribute royalties as required by law. Congress has also delegated authority to the office to develop regulations concerning many areas of copyright law. The subject of those regulations cover a wide range of topics, including rules governing submissions to the office, such as different types of copyright applications, fees paid for office services, filings related to statutory licenses, FOIA requests, and more. These regulations provide the public with a well-functioning copyright system. We also advise Congress on national and international copyright matters, and that includes the registrar, who is the head of the agency, testifying upon request and providing ongoing impartial expertise on copyright law and policy. The past few years have been particularly active as office lawyers assisted Congress with copyright review hearings and prepared numerous policy reports. Similarly, we work with government colleagues to deliver critical domestic and international policy analysis and advice. For example, we participate on U.S. delegations to international meetings and provide counsel to courts when significant copyright questions arise in litigation. And last but not least, we provide authoritative copyright information to the public by answering questions and developing educational programs. All of the great resources we're going to highlight here today that explain copyright have been developed, maintained, and updated by our staff. I'm now going to turn it over to my colleague Jessica to give us some copyright law basics before we dive into our myths today. Jessica?
Yeah, thanks so much, Laura. So before we get into a discussion of our copyright myths today, we just want to ensure that our audience has a kind of foundational understanding of copyright. Copyright law is found in Title 17 of the United States Code, also known as the Copyright Act. The law itself states that copyright protects original works of authorship fixed in a tangible medium of expression. And what this means is that we first must have a work of authorship, and that work must be fixed and original in order for it to be protected by copyright. A work of authorship, let's start there, is the subject matter of protected by copyright. And the broad categories of the types of works protected by copyright include literary works, such as books and novels, musical works, including any accompanying words or lyrics, dramatic works, including accompanying music, pantomimes and choreography, pictorial, graphic, and sculptural works, including fine and graphic art, motion pictures and other audiovisual works, sound recordings, and lastly, architectural works. Moving on to the second circle here, fixed basically means that the expression must be written, recorded, or otherwise captured in a copy and must be sufficiently permanent or stable for it to be perceived, reproduced, or otherwise communicated for more than just a transitory duration. The moment a work is fixed is the moment that copyright protection begins. And lastly here, originality in copyright involves two components. The first is independent creation, and the second is sufficient creativity. So first, independent creation means that the work must be independently created by the author, and that just means that the work must originate from the author and not be copied from another work. In theory, though, that means that two works could be the same or similar and each be subject to copyright protection, so long as the similarities are just a result of chance and not a result of copying. And sufficient creativity, that second element, requires that the work contains at least a small amount of creative expression, but that small amount must be more than trivial. For example, words and short phrases, familiar symbols and designs, including geometric shapes and typeface or lettering, are not protected by copyright. So that's a great point to end on here and help us transition to what you all have been waiting for, our very first myth. When people ask me where I work and I say the United States Copyright Office, the response that I'm frequently met with is something like, oh, wow, my cousin created this cool new invention, or my friend was recently talking to me about their catchy business name. And so we're starting our discussion of myths today with one that we hear all too often, that your business name, new invention, or idea for a story is protectable by copyright. Even though there is some overlap, Laura, help us out with the truth about business names, new inventions, and ideas.
Sure. So the truth is your business name, new invention, or idea for a story is not protectable by copyright, but they may be protected under patent or trademark law. Trademarks identify the source of goods and services. So for example, a brand name, a tagline, or a product configuration that help consumers identify the source of what they're buying or using. So business names, slogans, logos, they might be protected as trademarks. Patents, on the other hand, protect new inventive ideas, which might include discoveries, processes, methods, or devices. Copyright and the type of intellectual property that we'll focus on today protects creative expression fixed in a tangible form. Examples of creative works that may be protected by copyright include paintings, photographs, novels, films, musical works, and sound recordings. It's not uncommon for copyright to be mentioned alongside trademarks or patents because all three fall under a larger umbrella of law called intellectual property or IP. So IP generally refers to creations of the mind. And in terms of government agencies, the United States Patent and Trademark Office handles trademarks and patents, and the Copyright Office, of course, administers copyright law. This is our first resource corner of the day. So as I mentioned, we'll highlight several great Copyright Office resources throughout today's webinar. This handout is titled What Small Business Owners Should Know About Copyright. And while all three types of IP may be relevant for businesses, this particular handout focuses on the copyright concepts and considerations for small business owners, including the types of works they likely create during their entrepreneurial endeavors. And it also provides additional information on key takeaways, including licensing, the benefits of copyright registration, and works made for hire. And now I'm going to turn it back to Jessica for our second myth.
Great. So the second myth we have is this common misunderstanding that because you paid someone to create something for you, you now own that expression. And what we're talking about might be artwork for a website or a foreword for your novel. It's really easy to assume that because something is in your possession, you own the copyright in it. But Laura, again, help us out. What's the truth about copyright ownership, and what does it mean if someone's paid for creative content?
Sure. So the truth is, in general, the creator of a work or the author is the copyright owner. So just because you paid someone to create something doesn't necessarily mean that you own the copyright in the work. To explain this a little further, to be an owner, you need to be the author, but who is an author? An author is usually going to be the work's creator. However, in the case of something we call works made for hire, the author would be an employer or the commissioning party. So I'll go over both of those categories in just a moment, but just to reiterate the core message here, like paying somebody for creative content doesn't determine ownership of the copyright. And simply owning the work, such as a painting or a novel, that doesn't necessarily mean you own the copyright in that physical item. So as I mentioned, the first category of works made for hire are those made by an employee as part of their regular duties. So there are various considerations when determining whether the employer owns the copyright in an employee's work. So that includes where the work was created, whether the space, the tools, or materials that were used were provided by the employer, the level of control that the employer had over the work, and more. The second type of works made for hire are those that were completed as a result of an express written agreement between the creator and the party specially ordering or commissioning the work. So certain requirements need to be met in order to have a specially commissioned work made for hire. First, the work needs to fall into one of 9 categories mentioned in the Copyright Act. That includes, just for example, a contribution to a collective work, part of a motion picture or other audiovisual work, or a translation. And there must also be a written agreement between the party that ordered or commissioned the work and the creator. And in the written agreement, the parties need to expressly agree and state that this is a work made for hire. And finally, the agreement needs to be signed by all the parties. If those requirements are met, or the ones for an employee working for an employer, then you have a work made for hire, and the employer or the commissioning party would be considered the author and therefore the copyright owner. So again, paying someone to create something doesn't necessarily mean that you own the copyright in it. For more information on works made for hire, we encourage everyone to check out Circular 30. The office circulars have been around for a long time, and they used to be distributed by mail. Now they all live on our website and provide up-to-date and authoritative information on copyright law, policies, procedures, and registration issues. In Circular 30, there is a very helpful questionnaire that can help you determine whether or not you have a work made for hire. And that's particularly relevant for registration because when you're submitting a registration application to the office, you do need to answer the question about whether you're trying to register a work made for hire, and the office can't make that determination for you. So the questionnaire is a great resource to help you in your decision making. And with that, I will pose our next myth about copyright ownership. So here's the myth. Owning a copyright is just about preventing others from making copies of my work. When someone sees the word copyright, they might just think about the word copy and jump to the conclusion that that's the only right involved with copyright ownership. Jessica, can you help us with the truth here?
Sure. So the truth is that copyright owners have 6 exclusive rights in their work, and just one is what we call reproducing or making copies of the work. You might have heard of these 6 rights referred to as a bundle of rights. There are 6 total, again, including the right to reproduce or make copies of the work, prepare derivative works such as adaptations, remixes, or translations, the right to distribute copies to the public by sale, transfer of ownership, rental, lease, or lending, and then for certain works, the right to perform or publicly display them publicly. Additionally, the copyright owner of a sound recording has the right to perform the sound recording publicly by means of a digital audio transmission. Copyright owners can actually engage in any one of these 6 rights that you see here and can also authorize others to take the action the right provides. Copyright infringement generally happens when any one of these rights is violated, meaning when someone hasn't been authorized to take an action listed here. So for our next resource corner, we want to highlight the office's videos, specifically our Learning Engine videos. And we have in that series a great video on exclusive rights, and it can be found both on our website as well as on YouTube. The entire series includes 23 videos right now covering a variety of topics from the public domain to the history of copyright law and the office. And the link to our Learning Engine videos was just provided in the chat. So a general note here, the office has several playlists other than the Learning Engine video series available for viewing on its YouTube channel, including a playlist on copyright and artificial intelligence, and then others on the Music Modernization Act. You might have heard of the acronym there, MMA. So now that I kind of covered what copyright infringement means, let's clear up a common myth here about how it's the same as plagiarism. It's closely tied to the last myth I just talked about, that copyright is simply that right to prevent others from copying your work. But Laura, what's the truth about copyright infringement and plagiarism?
The truth is, copyright infringement and plagiarism are 2 different but sometimes related concepts. So plagiarism involves taking someone else's work or ideas and passing them off as your own. And on the other hand, copyright infringement is a legal cause of action when someone reproduces a work, makes a derivative work, publicly displays, distributes, or publicly performs a work without obtaining permission first from the copyright owner. So schools might have rules regarding plagiarism and what you should do to provide appropriate credit. However, giving credit doesn't make your use lawful if you use someone else's work in one of the ways I mentioned without permission, and it's not covered by one of copyright law's exceptions or limitations. In other words, copyright infringement is illegal, while plagiarism is an ethical concern with non-legal consequences that might involve social disapproval or educational discipline. Claims of copyright infringement can be brought before a federal court, and as of just over 2 years ago, they can also be brought before a new dispute resolution forum in the Copyright Office, the Copyright Claims Board, or CCB. The CCB can help resolve copyright disputes involving up to $30,000 in damages and can hear 3 types of copyright claims: claims for copyright infringement, claims for a declaration of non-infringement, and claims brought under Section 512F under the Digital Millennium Copyright Act, claims for misrepresentation. For more information about the types of claims I mentioned and how to navigate the Copyright Claims Board more generally, we encourage everyone to check out the CCB Handbook. That's the practice manual for the board. The handbook has over 20 chapters and is an in-depth and authoritative resource for filing, responding to and opting out of claims, seeking assistance with your claim, and more. For example, there are chapters specifically regarding how to start each of the 3 claims we just went over. The starting an infringement claim first page is on the tablet you see here. And there are also chapters relating to the service process, discovery, settlement, and how to present your case before the board. So we encourage you to check out this great resource and the CCB's website more generally if you're a potential CCB participant or if you just like to learn more. And while we're on the subject of copyright infringement, I'll also introduce our next myth about responsible copyright use. If I see a creative work on the internet, I can use it for free and without asking permission. So obviously there's a lot of content on the internet. Some of it is not behind a paywall and anyone can access it. So that access alone, might mean that someone can assume that the picture or the video or the story is free to use, or that the content's creator gave them implied permission by simply posting their work online to begin with. There are also various disclaimers that people use online, such as no copyright infringement intended, this is fair use, or these images are believed to be in the public domain. Jessica, with all these confusing messages and disclaimers on the internet, what's the truth?
Sure. So the truth is, just because something is on the internet does not make it free to use without the copyright owner's permission. There are several considerations that the Copyright Office would like to highlight today to encourage responsible copyright use, especially, in an increasingly digital world. First, understanding disclaimers, as Laura just mentioned, is really important. When you read a blog, including a found photograph, and that photo credit reads something like, "This is fair use," just maybe take a moment to think about that statement. Fair use is a legal doctrine, and a court evaluates fair use on a case-by-case basis, so the outcome of any given case depends on a very fact-specific inquiry. Other than disclaimers, it's also really important to consider that there's no implied license to use content just because it's been shared online. Requesting an express license is an important consideration then for responsible copyright use, and something that you can do alone or with the help of an attorney. The same is true for simply asking a copyright owner for permission to use their work. And lastly here, a responsible copyright user might also consider using public domain material. So the public domain is not a place, which is another kind of common misconception that we hear. But a work of authorship is in the public domain if it is no longer under copyright protection or if it failed to meet the requirements for copyright protection to begin with. So for our resource corner here, the office has no shortage of information to help you be a responsible copyright user. And no matter where you found a work, including if it was on the internet, if you intend to use material that you did not create, it's a really good idea to first determine if its copyright status, which just means whether or not the copyright term has expired, and if not, who the copyright owner is. So the office cannot grant you permission to use a copyright protected work, but you can start your research into the copyright status of a work by searching the records that the office maintains. The official online public catalog is where we'll start. We'll share a link in the chat now, and that contains records of copyright registrations, as well as transfers of copyright ownership created after January 1st of 1978, all the way to the present date. Pre-1978 records, that just means records created between 1870 and 1977, are searchable on site in the Copyright Office in Washington, D.C. And this card catalog has also been digitized in a proof of concept virtual card catalog. And then turning to our highlighted resource on the tablet here, searchable card catalog records are also included in in our new Copyright Public Records System, or CPRS for short. So CPRS is in its pilot, but the office continues to develop it so that users have this kind of single, easy to navigate, and highly searchable database of Copyright Office public records. The pilot does not yet replace the official online public catalog, but it will in the future. So it's just another great resource or tool to use when researching the copyright status of a work that you're interested in using. And when accessing CPRS, you can try out both the simple search interface and the advanced search interface that includes a query builder and filters. All that to say, last month in August, we held a fantastic webinar called Level Up Your Copyright Public Records Search that include a demonstration of CPRS's powerful search capabilities. And the webinar also included information on additional kind of research and support services that the office provides to the public. So we encourage you to watch the recording at the link in the chat if you're interested in learning more about navigating CPRS. So let's stay with the topic of using someone else's content for our next myth here. We often hear a lot of misunderstandings around fair use, and this one focuses specifically on, when a short maybe blurb or snippet or clip is being taken from a larger work and used in another work. So we'll use the music industry as an example here, and taking a closer look at sound recordings, which are the recorded performance of sound. The myth here is that it's fair use if I only use a sound recording that is 6 seconds or less. Examples of sound recordings include songs, but they might also be audiobooks or podcasts as well. So Laura, if I only use 6 seconds of a sound recording, that's definitely fair use, right?
Sorry. Here's the truth about fair use. Fair use is decided by a court or by the Copyright Claims Board on a case-by-case basis. So there's actually no set formula for determining whether a use is fair. It's a legal doctrine, and fair use promotes freedom of expression by permitting an unlicensed use of copyright-protected works in certain circumstances. And it's used as a defense to copyright infringement in legal disputes. So the Copyright Act includes a list of activities that may qualify as fair use, and you might have heard of some of these. They include criticism, comment, news reporting, teaching, scholarship, and research. However, a court evaluates fair use on a case-by-case basis using 4 factors that are set in the law: the purpose and character of the use, the nature of the copyrighted work, the amount used and how substantial it is, and finally, the effect of the use on the potential market for or value of the work. And the outcome of any given case depends on the facts. So that means that there's no specific formula or number of words, lines, pages. There's no particular number of seconds that ensures that the material can be used without permission. So if you're concerned whether your use would be considered fair, it's often best to consult an attorney. As part of our discussion of fair use and the various ways creators might use existing content, you might want to visit our collection of web pages that encourage you to engage your creativity. We'll put the main landing page in the chat. These web pages highlight a collection of resources for specific creators. For example, the web page shown on the tablet here, What Musicians Should Know About Copyright, provides musician-specific resources, including our handout titled Sampling, Interpolations, Beat Stores, and More, an introduction for musicians using pre-existing music. And there's actually a discussion of fair use on page 10 of that handout. Now I'll take us forward to our next myth on copyright duration. So as we think about the public record for copyright ownership, the public domain. A common question is, how long does copyright last? And some think that copyright lasts forever. Copyright duration has changed over the years. For example, the first federal copyright law in 1790 protected registered works for 14 years with an option for an additional 14 years upon renewal. In the 1800s, that increased to 28 years for the first term, and there was another option to renew for 14. Under the 1909 Act, the term was set at 56 years. So under the current copyright law, the Copyright Act of 1976, what is the truth about copyright duration today?
So the truth is the term of copyright, meaning how long it lasts, depends on who the author is. In general, though, the copyright term is limited. And before we get into today's law that Laura just kind of touched on briefly, we can take another look back at the language provided in the Constitution's Copyright Clause, which is in Article 1, Section 8. So the language from the clause says that copyright's purpose is to promote the progress of science by securing exclusive rights to the author's writings for limited times. So essentially, it would be unconstitutional for copyright to last forever. Copyright law today provides a current term of copyright protection that lasts for the life of an author plus an additional 70 years. We discussed earlier works made for hire, and the term of copyright protection for those works is 95 years from the work's first publication or 120 years from the work's creation date, whichever is shorter or whichever expires first. So if you're wondering whether, anonymous and what anonymous and pseudonymous works are, we have a few minutes just to cover those now. Essentially, in copyright law, particularly in copyright registration, an anonymous work is one on which no natural person is identified as author. So on the work itself, there's no person named or identified. And then on a pseudonymous work, it's a work on which the author is identified under a fictitious name. This is another common misunderstanding that we hear a lot, and that's an abbreviated name or a nickname is a pseudonym. But the truth is that a pseudonym is a fictitious name, completely made up, that an individual author can use to identify themselves to the public. So for example, the British writer J.K. Rowling, her full name is Joanne Rowling, so she's used an abbreviated name, J.K. there, and then a pseudonym, well known for other books, is Robert Galbraith. But getting back to our overarching truth about copyright duration, when copyright protection ends for any type of work, that means a work made for hire, an anonymous or pseudonymous work, any type, that's when we say its term expires. And when the term expires, a work enters the public domain. So to expand on the public domain, once copyright protection ends, the exclusive rights of a copyright owner no longer exist. And this means that the work can be reproduced without permission, it can be performed or displayed publicly, and may also be used in the creation of new works, again, such as adaptations and translations. So as you can likely tell, that means the public domain has really important historical and cultural benefits in the life cycle of copyright. So for our next resource corner, what we've highlighted here for you is our public domain blog post on the office's blog, which is titled Creativity at Work. And while the office does not compile nor maintain a list of all of the works entering the public domain, each year what we do is publish a blog post that highlights some of the works entering the public domain in January of that given year. And so this year, we highlighted a number of works published in 1928, which entered the public domain in January of 2024. So this post and others on our blog can be read at the link that was provided in our chat. But other than that, over to Laura for our next myth.
Thanks. So here's another very common copyright myth, and that's to protect your work, you need to mail it to yourself or register it with the Copyright Office. The first part of this myth comes from a common misconception that if an author mails themselves a copy of the work and preserves the unopened package, they'll have a date stamp on the envelope that verifies the date the work was created on or before a certain day. However, that doesn't prove authorship of a work. And in terms of registration with the office, the confusion might stem from what we mentioned earlier regarding other areas of intellectual property. So for example, to obtain a patent, you need the government to review and approve a patent application to secure your rights. So Jessica, if I don't need to mail the work to myself or register it with the Copyright Office, what's the truth about securing copyright protection?
So the general truth is that under the current copyright law, again, that's the Copyright Act of 1976, no formalities are required to secure copyright protection today. And this means that a registration application does not need to be approved, nor do any sort of special symbols or notations have to be put on the work. We love talking about the history of the law here at the office, and for some additional insight, under older copyright law, it used to be true that the copyright notice, which is the C in the circle, had to be used on a work in order to secure copyright protection. You might see that copyright notice, the C in the circle, or the abbreviation COPR in a book's title page or during the end credits, of a TV show that you're watching. But again, under the current copyright law, copyright notice is now optional for works created after March 1st of 1989. The key point that Laura just mentioned, and I mentioned earlier on as well, is that under today's law, works are protected by copyright as soon as original work of authorship is fixed. That's the moment copyright protection begins. So you might pause here and wonder, why would someone register their works then with the United States Copyright Office? And while it's true that registration with the Copyright Office is not required, it is recommended. If you want to register your works, the U.S. Copyright Office, again, is the only place that you can do so. We run the nation's only copyright registration system. And just to kind of clarify, there are a number of benefits to copyright registration, and we'll cover 3 here today. The first relates to the public records we were just discussing. When you register your work with the office creates a public record that includes key facts about the work, such as who the author and the owner is, the title of the work, and if it's been published in what year and country publication occurred. So in this way, the public record contributes to the public record of creativity. Our records might reflect that a work is in the public domain, which then allows others to make copies of or prepare derivative works based on the original work. And so we're talking about fueling creativity. The second benefit here is that registration also helps potential licensees or people and entities interested in obtaining permission to use your work to find your contact information. And then third, copyright registration opens the door to enforcing your copyright. And what we mean by enforcing here is essentially pursuing a copyright infringement lawsuit or a claim. If a copyright owner's exclusive rights have been violated and they want to file a copyright infringement lawsuit in federal court, then the office must have issued a registration decision, which just means we either have to have approved or refused registration of your work. And then a registration application does need to be approved by the office in order for the Copyright Claims Board or the CCB, which was an alternative to federal court, for them to issue a determination. All right, so we highlighted a different circular earlier on in the presentation, but here is another great one. Circular 2 covers registration in depth, from whether or not online or paper filing is right for you and what a deposit copy is. So deposit, that's another confusing word. To many of you, you might hear that and think about a monetary deposit, but in copyright registration, the word deposit refers to a copy of your work. There is a monetary payment required, but that's typically just called a fee. And Circular 2 kind of explains all of this, as well as explains the date the office receives these 3 components, the application form, the deposit, and the fee. That's what's called the effective date of registration. So before we move on, you may have noticed that this particular circular is in Spanish. And so the office has translated a dozen circulars into Spanish, including Circular 2, and you can find them all at the link in our chat now. I just wanted to note that September is Hispanic Heritage Month, or it started on September 15th. So it's a great time to kind of remind our audience of other Spanish resources, including handouts related to the Music Modernization Act and an updated frequently asked questions or FAQs page. So please keep an eye out for additional resources, handouts, and web pages in Spanish in the future. Moving on, though, copyright registration is one of the office's primary functions, and so let's explain another myth related to registration next. This next myth is that you cannot file a copyright registration application without a lawyer. And we've talked a lot today about copyright law, and the registration process does require that you meet certain legal and formal requirements. So it might be easy to assume that a copyright registration is a very complex process that involves a lot of maybe legal jargon that's difficult to decipher, or some really complicated hoops that you have to jump through. But what's the truth about the registration process?
So the truth is, in most cases, you can file your own registration application with the office. It might be helpful to consult a legal advisor, but the office also provides many resources to support you during this process. We have tutorial videos and FAQs, and we also offer a great service out of our public information office that I'll go over in just a minute. But in terms of the registration process itself, we do want to provide some clarity around the expense and timing that might make it seem less complex or overwhelming. So first, let's start with the expense. Applications can be submitted online using Echo, and the fee you pay will depend on the number and the types of works you're trying to register. So the general rule is that you must submit one work with one application. And our most inexpensive form there is $45. However, the office has also created a number of group registration options that allow you to submit more than one work on one application. Most of the group options are required to be submitted online, and those applications range in cost from $55 to $95, depending on the type of work that you're submitting. The office also provides paper forms, so if you're interested or need to submit a registration application in the mail, the most inexpensive paper form requires a $125 fee. And in terms of how long registration takes, generally just a little bit over a month. The office frequently posts its registration processing times on our website, and we've just summarized some of the details here. So for an online application with an electronic copy of the work, the processing time is averaging about 1.2 months. And when no communication is required with the applicant. So that's what the words no correspondence mean on our registration processing times page. When the office did need to communicate with the applicant, the average processing time increases just slightly to about 3.5 months. And in general, an application submitted that's using a paper form, it's taking about 4.1 months to process, and that's again when no correspondence was needed. So I mentioned our public information office service. We provide many different types of guidance on registration, including a lot of the resources that were already mentioned today: circulars, our Engage Your Creativity web pages, our online videos. But registration help can also be provided live through what we call a walkthrough appointment. And that's a service where a copyright office staff member assists you in navigating an electronic registration application by explaining the various screens and the types of information required. Just some additional notes to keep in mind about walkthrough appointments: you will need to have your Echo username and password ready. The walkthroughs are all conducted by phone, and they last about 30 minutes to go through one application. We do also offer in-person walkthroughs on request. And it does take a few days to process these, so we very much appreciate your patience with us with this process. We have appointment times that are available Monday through Friday, 8:30 to 5, and the last appointment does start at 4:30. And if you have a question when the staff member is conducting your walkthrough, they can't provide legal advice, but they might be able to give you some resources or additional context. So we do ask that if you'd like to schedule a walkthrough appointment, please use the online form, and we'll put the link to that in the chat. And with that, I will introduce our final myth for today, which is copyright does not affect me because I'm not a paid creator. Maybe you've only read or seen famous musicians or singers in various legal battles regarding copyright. Or you might have seen copyright mentioned in a movie's end credits, for example, or on the title page of a book. But Jessica, what is the reality here? Is copyright only for creators who are paid for their work?
So the truth is that copyright affects absolutely everyone. We are all copyright owners and users. And the examples that Laura just provided, music, movies, and books are how many people likely generalize copyright. But if you break down the larger categories of copyrightable materials, performing artworks, motion pictures, visual arts, and literary works into these specific examples of copyrightable works, you can kind of quickly see how copyright surrounds us all in our daily lives. And that is true even if you don't consider yourself, a creative person or aren't getting paid to create. So for example, in the category of performing arts, works protectable by copyright might include dramatic works like plays and operas, sound recordings such as podcasts and audiobooks, musical works including lyrics and choreography. And then motion pictures include audiovisual works, which encompasses TV shows and video games. If you're a small business owner, maybe you create videos explaining the products that you sell or the services you provide, and that content falls under this category as well. Visual artworks might include paintings, drawings, photography, but this category also captures some unique things like sculptures, jewelry, and architectural designs. And again, for small business owners, this might look like artwork in your logo, product label, or your advertising materials. And lastly, we have literary works, not just books and newspapers. These could also include magazines, computer programs, blog posts, and more. But hopefully that kind of fresh perspective on the depth and breadth of copyright sheds some light on why the Copyright Office has a strategic goal that we call Copyright for All. So this goal and the entire strategic plan highlight copyright's increasing relevance to society. And as part of our efforts to expand our outreach and education programs and kind of grow awareness of copyright and its benefits, that Copyright for All goal essentially aims to make copyright as understandable and accessible as possible to everyone, from individuals to businesses of all ages and sizes. The other three goals that you can find in the strategic plan include continuous development, impartial expertise, and then enhanced use of data. So the focus on this last goal means that we're enhancing the use of data as a decision-making and performance measurement tool and making that data available to stakeholders who can help advance copyright knowledge. And advancing economic research on copyright through the Office of the Chief Economist plays an integral role in achieving those goals. So on that note, I'm very excited to tell you about our final resource here, our Resilience of Creativity study. The study reveals the impact and subsequent recovery from the COVID-19 pandemic in terms of employment, revenues, and creative outputs in the copyright-reliant industries. Copyright-reliant here means that the industries primarily rely on copyright for their core business models. And the study identifies actually 18 different industries, ranging from architectural services to news syndicates, TV broadcasting, radio networks, software publishers, photography studios, and more. And it's these 18 industries that produce the types of works registered with the Copyright Office. So the data and the findings in the study help amplify this very important point that copyright is all around us, and in that way, copyright affects all of us. It affects everyone. And if you're interested, the Office of the Chief Economist also just released a new study last week on the geography of copyright registrations, and that can also be found on our website as well. So that was actually our final myth. Thank you all so much for listening in. I'll turn the floor back to Laura, who will provide some closing remarks and lead us into our Q&A as well.
Thanks, Jessica, and thank you everyone for joining us today. We highlighted many great Copyright Office resources, our circulars, our Public Information Office, our videos, the Copyright Public Records system, and our Engage Your Creativity web pages. That's all available on our website. Again, that's copyright.gov. And for updates from the office, you can also subscribe to our Newsnet. That's our digital newsletter. So we'll drop the link in the chat so you can subscribe to that and other subscriptions like our blog, our events, updates, and legislative developments. And we also encourage you to follow us on X and LinkedIn. So we're now happy to take a couple of questions. I'm going to turn it over to George to start us off.
Wow, wow, wow. So much great information. That was really amazing. And I know you're all blown away with all of what you learned today. And there's more. And of course, you have many questions. We have so many questions. We won't be able to get to them all, but you know how to contact us. And please do, because we have people ready to answer your phone calls during regular business hours on the East Coast and also by email. But let's dive into a few questions that have come from all of you. One of them is, Okay, Jessica, I'm tossing this to you. You mentioned about published versus unpublished, and if you could touch on what the difference is, and specifically, there's a question if somebody posts some images on their Facebook page that are only available to their Facebook friends, is that published or unpublished?
Sure, thanks, George. So I'll start with some general information about what publication means. Publication is a very specific meaning in copyright law, and it does mean that it's been distributed to the public for purposes of sale, rental, lease, or lending, or it's been distributed, or I'm sorry, offered to a small group of persons for that further distribution. So it does have that very specific meaning. And then regarding, the context of the digital sphere or online world, that is a tricky question that the office continues to examine. We actually have an open rulemaking on what it means to have a work be published online. So I encourage you to take a look at our website for more information and keep up to date on any updates there. But in general, the Copyright Office's view can be found in the Compendium of Office Practices. It's not a resource that we highlighted today, but it's a fantastic practice manual, and it contains some information on the express authorization that must accompany something being posted online, and the ability also to download. So it's not just the posting that is enough in order for it to be considered published. Back to you, George.
All right, thank you. Here's another question for you, Laura. You've used the term fixation, the copyright is fixed. What does that mean, copyright is fixed?
Sure. So fixation is a very specific term, and I know Jessica mentioned it at the top as one of the 3 requirements to have a copyright protected work. And fixation just means that something is written down or recorded in some way that it can be perceived or communicated to somebody else. So think of something like a photograph. When you take a photograph, even if it's on your phone, it is saved on a server somewhere. And so even digitally, works can be fixed. So it's usually doesn't come up as a particular issue, but it's important to keep in mind. And I'm going to turn to the compendium again, because there is a really great, there's really great explanation of fixation in there and some counter examples as well. Back to you, George.
Thank you. And here's a question. We've gotten a couple of questions. We could do a whole separate webinar on this, but just briefly, can a work created through the use of AI be copyrighted? And I'll pitch that to you, Jessica.
Sure. So the question of regarding any AI generative technologies is, of course, something that the office continues to study. Right now, the office's stance is that material is protected by copyright if it was created by a human author. So if it was solely created by generative AI technology and you are trying to register that work, it's very likely that the office will refuse registration. Again, if it was only created by generative AI technology. If it involved AI generative technology, but there is still that human authorship component, there is a requirement explained in our registration guidance to disclose that AI generated material. So as George mentioned, we could spend a whole separate webinar talking about AI updates. And so I'll keep kind of the work that we're doing around AI and our AI initiative really brief here, but the gist is the office has done a ton of work in this area. It can all be found on our dedicated webpage, which is copyright.gov/AI. I hope that someone can drop a chat. Awesome. A chat in the link. A link in the chat, I'm sorry. Basically, we issued a notice of inquiry last summer. This was in August of 2023. We received over 10,000 comments as of last December. We hosted a number of public listening sessions and webinars in the process of issuing a report that analyzes a number of issues related to copyright and generative AI technologies. So part 1 of the report, excitingly enough, it looks at digital replicas, and it was published on July 31st, so just a couple of months ago. And the remaining parts will be published as they are completed. So please check back on our website for more information. And as to the registration question, hopefully you can also find the registration guidance on that webpage as well.
Okay, thank you. Here's a good question that comes up a lot. Can you waive your copyright via a terms of service agreement or statement?
I'll take that one. Thanks, George. So in terms of service and waiving copyright, on different various third-party websites that you can pull images from, there's very specific terms that are included there, and they actually all kind of function as licenses in and of themselves. So it's important to keep in mind that when you see things like terms of service or you're agreeing to certain things, to really read the specifics of what that entails, and to consult an attorney if you have any questions or concerns. So it's basically important to read the fine print here, right? And not just kind of click through, because you'll find that, many of the things we've talked about today, including your rights, you'll see some of the terms in there, and you want to be aware of, what you're agreeing to and what the site's policies and procedures are concerning your copyright. Thanks, George.
Okay, great. All right, here's another good question. My understanding is that any written, creative, and original text could be copyrighted. If this is the case, can an economic development project be copyrighted?
I guess the ultimate answer there would rely on whether it's been fixed, but sure, when we're looking at either projects or project proposals, if it's in a form like that creative expression form that we've talked about, so written, recorded, or otherwise in a form that can be perceived and then reproduced as well, then we're talking about something that is potentially copyrightable.
All right, thank you. So we talked a little bit about fair use, and there's a follow-up on fair use. Can you speak to fair use for images that are on social media, particularly for nonprofits?
Yeah, that's a great question. So as we mentioned during the presentation, there's a lot of content on the internet, on social media, and people tend to use a lot of disclaimers on there as well. And we just want to encourage everyone to kind of stop and think about what those disclaimers say, because fair use is not something that can simply be declared by someone. As we mentioned in the presentation, it is something that's decided by a court. It's used as a defense to copyright infringement, and it's a very fact-specific inquiry. So it's going to depend on a number of factors. Nonprofit status of an organization may be one of them, but really it's going to be up to a court to kind of balance the various facts in every scenario with those 4 factors that I mentioned before.
Okay, thank you. Okay, here's a question. Can the government, a taxpayer-funded office, hold the copyright?
So the United States government can hold copyright if it's been transferred to the government, but this is a great opportunity to kind of shed some light on the resources that are available to you on copyright.gov. So those are all resources likely created by employees of the U.S. Copyright Office in the scope of our employment. And when it's been done that way, the work is not protected by copyright. And that is, of course, an answer related to federal government. And we do have additional resources on state and local government, especially like, legal doctrines and legal edicts as well on our in our compendium. We mentioned that a lot today, so hopefully folks can find that very easy to find on our website.
Thank you. We have a lot of questions about registration. Here's one. As a photographer, is it best to register singularly each photo or as a group, or would it depend on the photographer and the photo?
Yeah, that's a great question. As I mentioned, we do have group options where you can submit more than one work for the application. So I think that the best place to start there would really be our registration portal. There's a number of options for photographers, and you can kind of read up on, what those different options entail and what the requirements are for each one, and then, make a decision that seems the best for you. And depending on how many works you want to do, whether they are published or unpublished, there's various considerations. So I would definitely start with the registration portal and the Engage Your Creativity web pages as well.
All right, thank you. And one more question. Can a child own a copyright?
I'm so glad this is a question. So a minor can absolutely claim copyright, and the U.S. Copyright Office will accept applications for registration submitted either by a minor or on behalf of a minor. You may just want to keep in mind that registrations, again, are publicly available. So the information on them are publicly available, including a minor's name and their address, potentially their date of birth as well. But in general, the point we want to talk about, why I love this question is because it goes back to the idea that copyright is for all, including kids, teenagers, young adults. And I really hope that, our parents and educators out there who are listening can help us spread the word on that. Thank you.
Well, thank you so much. And we have learned so much today. I know that there are a lot more questions, but please contact us. Also, this webinar has been recorded, so you can go back and review it for things that you may have forgotten. And we welcome all those who are watching this on YouTube at a later time. So please continue to follow us. All of the great information we've talked about is on copyright.gov. We'll be sending a survey later. We're really interested in your feedback to help improve these programs. And we thank you for connecting with us, and thank you for joining us today. Thank you, Jessica and Laura, for your great presentation today.
Thanks so much, George. So as George mentioned, find us online if you'd like a speaker to speak at an event that you have or a class. We have a speaker request form. We'll put the link in the chat. And yeah, if you have any additional questions about today's presentation, feel free to contact our public information office. We'll drop the link in the chat to the contact form again, and the phone number and email. Thank you so much again for joining. It's a pleasure being with you today.